Well, thank you everybody for coming. Let me say just a few brief words before we start. This initiative to organize a colloquium with Münster University and University of São Paulo Law School, I think it's caused a lot of a model for doing partnerships. I mean, usually we start partnerships writing paper agreements that sometimes simply keep on their paper status for long. Sometimes they are transformed into an agreement through exchange students, sometimes not. But here, besides doing all the efforts in order to sign our paper agreements, we're moving on this direction, we decided to track a different strategy, which is to start to making this kind of small colloquiums in which we'll have the opportunity to face-to-face kind of interaction and inviting our community of students and of professors. We start in Münster, and it was a great colloquium, very pleasant. We have been received there with a lot of sympathy, warmth, and very wonderful colloquium, not only from the, let's say, academic perspective, but also from the personal perspective, which is also one of the targets of this colloquium. And it's different also from other kind of seminars because it is addressed to putting together people from many different areas. So this is not a colloquium on legal theory or constitutional law or criminal law exclusively or commercial law, etc. But this is an opportunity for matching, for putting together, for putting partners, or future partners for a collaboration. So I'm very happy that it was really successful in Münster. I hope it will be successful here too. I was talking to Niels, who is the person I was interacting more directly to organize this from the very beginning. The idea here is that, well, Niels will make most of the introductions to the German community of faculty. Myself, or other will introduce our Brazilian partners. I'd like to say that I introduce for you all Cynthia Gonçalves. She's Brazilian, and she's the person here for you to get in touch if you want to know more about Münster, about the possibilities. Münster is a very organized, well-organized institution, and they have an office here in Brazil, in Sao Paulo. So she's the person, she's the liaison for all other meetings. And I'm also especially stressing these for the students and also for the academic community. So get in touch with her. She's not one of the speakers in the seminar, but she's a key person in this seminar too. Well, we have our schedule here. We are on schedule, at least now we still are on schedule. And the idea basically is to offer 45 minutes for each of us, not only to introduce, to discuss the subject, but also to save time for the debate. So the whole time everyone will have is 45 minutes. My recommendation, but this is really just a recommendation, to talk not more than 25 minutes or maybe 30 minutes. I mean, you take the control of your time, even though we'll have someone who will be also helping in this very difficult task. But I mean, control your time so that you'll have enough time for the discussion, which is really a key dimension of this kind of colloquium too. Okay, and we are going to, for those of you who are the faculty members, we are going to have lunch here at the university, at the Associação dos Antigos Alunos, Old Students Association, has offered the lunch for these 2 days. And that's it. So since it's not exclusively an academic, intellectual experience, since it's also an academic experience in its fuller, more broad, comprehensive dimension, try to get in touch. That's the reason. That's the basic reason for us to make an in-person kind of meeting. That's the reason why this is not a Zoom meeting. We have done some others, but this one, it's very important because we have this special opportunity. So, well.
Thank you so much, Ronaldo. I still remember well when we were sitting here, it was almost exactly 3 years ago, and we were discussing, I think you made the proposal that we have these joint seminars, and I thought that's an interesting proposal. Let's see whether we can make it work. I was a bit skeptical, but indeed we were able to make it work, and I think Münster last year was a fantastic start. I think initially we only planned one session. It was so well received that we thought, let's do it again in Sao Paulo this year. So thank you so much for hosting us. We are really grateful that that you're hosting us here, and we look forward to the seminar. So initially you suggested that we make a brief introductory round. I don't know, should we still do that considering the time? But
just so that everybody knows from the very beginning who's who here. At least to know the name.
Maybe just maybe I just point out the name so that we so I start in the back with Nils-Jansen, who is a professor of legal history at the University of Münster. Then we have right next to him Gerald Mesch, who is a professor of commercial law at the University of Münster. Then we have here in the front OliverLepsius, who is a professor of constitutional law and legal theory at the University of Münster. James Folks, who is also professor of constitutional law, and I think we call you professor of foreign law because the Germans don't really know how to deal with people who don't have their core expertise in German law, but he really is an expert in comparative constitutional law. And Stephanie Kemme, who is a professor of criminology. Myself, I'm a professor of international law and constitutional law, comparative constitutional law, and we are still missing Michaela Heilbronner, who's also a professor of constitutional law, comparative constitutional law. She's feeling a bit unwell this morning, but we hope that she will be able to join later.
Okay, so my turn for the Brazilians. So here we have Virgílio Afonso da Silva, who is professor of constitutional law here. Conrado Hübner, who is also professor of constitutional law. Professor Massoneto is professor of economic law and regulation. Professor Ana Maria Nusdeu is professor of environmental law. Professor Maria Paula Dallari is professor of public law, regulation, education, many different subjects as well. We have here, Juliana is Professor Kruger. We have some German affinities here. Juliana Kruger is Professor, Pella is a professor of commercial law. Am I missing? Okay. And we have here Professor Leonel is professor of civil procedure, who is also here to join us. And would you like to introduce yourself so that because you are not from OSP? Yeah. Okay. 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 Wanderlei was also part of our colloquium in Münster last year. And we have Professor Lucas Fucci, who is professor of the Department of Legal Theory and Jurisprudence, who has been working very deeply with issues concerning sociology of law, Nicholas Luhmann, and also legal theory. So and it will be other faculty members will join us later. I think it's better to introduce them later. Okay, so that's it. So let's start. Let's save our time And so I'd like to invite Professor Lepsius to come here. And yeah, and then we can change places. Would you like the chat? No, I can.
So it's my pleasure to introduce Professor Oliver-Lepsius, who came this morning at 5 a.m. He arrived here in Sao Paulo, and he's fresh as if he had had a whole night of sleep. So we are very happy to have him here. I already said that he's a professor of constitutional law and legal theory, legal philosophy. Is it legal philosophy or legal theory?
I don't like legal theory.
So legal philosophy.
Theory enables everyone to everything. Legal philosophy requires some more detailed expertise.
Everyone
Theory does not require nothing. You know, everybody is able to be a theorist, but not everybody is able to be a philosopher.
Wonderful. So legal philosopher Oliver-Lepsius, who will talk to us about the political function of constitutional jurisprudence in Germany. Oliver, you have the floor.
Oh, thank you. Do we need the microphone actually? Yeah, we need the microphone because this gives me a little bit of troublesome situation here. The paper, and I feel like a chanson singer, yeah, now with yeah, okay. Okay.
Yeah, we are.
I don't, okay.
Yeah.
So.
Because we have some audience
online. Okay, online. Yeah. Okay. Yeah, we need it for the a far relative of my wife is Rudi Carrell, and so I think perhaps you know him. It's a Dutch popular pop singer, and so in in the name of Rudi Carrell, yeah, I try to do my best with the microphone. Well. Welcome to this session, and I'm very grateful to be able to give a presentation here at your most renowned university. The German Federal Constitutional Court, I use the abbreviation FCC, and furthermore, is both a court, which is obvious, but also a constitutional body. This dual structure has been the cause of interpretation problems and jurisdictional conflicts from the very beginning. On the one hand, as a constitutional body, Karlsruhe, we very often refer to the FCC simply as Karlsruhe, yeah, as an abbreviation, the name of the city where it is based. Karlsruhe is part of the sphere of political institutions, while on the other hand, it remains a court, subject only to law. On the political stage, the court speaks the language of the judiciary, and on the judicial stage, it also speaks the language of politics. The court structure gives rise to organizational and procedural characteristics that distinguish the FCC from other constitutional bodies. It's not designed as a representative body. It's neither subject to control by the voters, nor is it accountable to them. The FCC can only act upon request. Its decisions, however, have the force of law and cannot be changed deliberately. In contrast, other constitutional bodies, imagine the parliament, can renegotiate any federal law at any time and change it at any time in conjunction with the Federal Council, the Bundesrat. Therefore, as a constitutional body, the FCC operates under the functional logic of a court. This limits its decision-making activity to disputes that are based on constitutional law and must be justified before the court, in contrast, let's say, to political decisions which are justified before voters. One could now infer that because the court neither needs to meet democratic requirements nor apply political standards, the FCC necessarily decides in a purely legal way, namely according to the standard of the Constitution and in the forms of special procedures standardized by law. Yet, the FCC decides not only as a court, but also as a constitutional body. And constitutional bodies relate with other constitutional bodies. The constitutional framework leaves room for dynamics, the situational and context-related concretization of constitutional standards. Consequently, the FCC has always reacted and is politically accountable within a system of competences. For example, in 1983 and in 2005, the FCC accepted the faked votes of confidence, which are a prerequisite for the dissolution of Parliament, when it argued that the constitutional bodies involved, the Chancellor, the Parliament itself, and the President, jointly wished for the dissolution of Parliament and new elections across party lines, even though the constitutional text does not open up the dissolution of Parliament to political discretion. The FCC interpreted the constitutional role, therefore, in accordance with situational practice and political wishes. Conversely, in the case there is a suspicion that organs are attempting to advance their interests in opposition to those of other organs, the court intensifies its look and exerts a more rigorous interpretation of the Constitution upon the political process. We might think of the increasingly detailed control of federal electoral law because the voting rules did not have the support of all of the parties. So this indicates a level of mistrust then to the outcome of the legislative process. Whether constitutional norms are interpreted flexibly or rigidly, therefore, has to do with the context in which they are applied, which in turn must be understood within the context of a living democracy. The Basic Law aims to enable democracy, not to constrict political life in a corset of rules. The Constitution, therefore, wants to be interpreted and applied in a democratic manner. This produces diverging constitutional interpretations. The court may interpret the same provision in a more or less restrictive manner, depending on the circumstances and the potential consequences for the political system. This standard of interpretation, in the name of democratic functionality and depending on context, also depends on procedural requirements, the rule of competence of the FCC in particular. If the Basic Law provides for an abstract review of norms, and it delivers this competence to the court should review norms in an abstract way, then the Constitution permits the continuation of the political debate with the means of constitutional procedural law. When the Constitution provides a constitutional complaint by citizens, it enables these citizens to become constitutional litigants beyond the protection of their individual rights. The Constitution permits the Karlsruhe courtroom to serve as a forum for the renegotiation of politically determined issues under different legal constraints, be it at the request of the opposition, in the case of abstract norm review, disputes between organs or federal state disputes, or be it at the request of minorities in the form of a constitutional complaint, or be it at the request of other courts, concrete norm review procedures. A few examples. In 1969, the FCC compelled the German Bundestag to enact legislation on the equality of illegitimate children born out of wedlock. The basic law contains a corresponding constitutional mandate, Article 6, Section 5, which the Bundestag, however, did not implement for 20 years. That was due to political majorities. It was a conservative government, and that was not on their agenda, although the Constitution required action. The FCC announced if such a law was not passed within 6 months, Article 6 of the Basic Law had to be applied directly in the replacement of statutory law, and hence would supersede the provisions of the Civil Code. Extreme menace, so to say, to the political process. The legislature did as it was told, and within very brief notice amended the Civil Code, which it had not done for 20 years. In 1975, second example, the FCC declared the modernized abortion law unconstitutional and demanded that the Bundestag maintain the criminalization of abortion and introduce a different model based on indications. The Bundestag had only very limited room for maneuver in reforming the abortion law after the court decision. The will of the voters in the previous election, in which abortion law was a major political issue, was simply ignored. Third example, in 1978, the FCC declared that the safety standards for the use of nuclear energy could only be determined by government through executive orders, and may not be determined by Parliament by enacting a law. It must be an executive order. Hence, government action, not legislation. A key policy area, nuclear energy and its use, was removed from parliamentary jurisdiction and transferred to expectocracy. Does that word exist in English? It exists. Yeah, because in French, they don't know it. Expertocracy, my French colleagues tell me that doesn't work. Okay, but in Romanic countries, expertocracy, because the French colleagues told me it's a mixture of Latin and Greek, and that's against grammar rules. English doesn't care about grammar rules, and the Germans don't care either. So if expertocracy is permissible. Yeah. Fourth example, in 1985, the court declared a restrictive authorization and dissolution practice for large demonstrations to be unconstitutional. The police were not permitted to disperse a demonstration without further ado, merely on the basis of forecast of danger. The police are not only entitled to protect public safety, but must also do everything in their power to ensure that peaceful demonstrators can exercise their fundamental rights, even if violent forces are mixed in with them. To date, this decision has enabled the holding of large demonstrations, which are often affected by militant individuals who engage in disruptive and unlawful conduct. All of these decisions are highly political. They interfere with majorities explicitly. They change the political division of responsibility between the three branches of government. They make the influence of voters and citizens more difficult or sometimes even easier. In addition, two more recent decisions are worthy of being mentioned, namely the climate protection decisions of March 2021, when the court forced the legislature to bring forward carbon restrictions, and that has been perceived by many as a political encroachment of the court. A contrasting picture emerges from a decision of November 2021, in which the FCC refused to override the nighttime exit ban in the pandemic, the so-called federal emergency brake in German, Here, the FCC is shying away from the political process and ultimately does not want to damage then Charles Merkel, who had advocated this very restrictive rule in the Bundestag. So basically, at the same time, we find a restrictive decision, pandemic law, and an encroaching decision, carbon reduction laws. Such decisions are political not only because they concern issues of day-to-day politics, they are also political in a broader, not party affiliated sense, because they do not take into account the functionality of democracy. In 1969, that was the children's case born out of wedlock, the FCC would not have had to constrain the legislature. It had not done so for decades, but after 20 years, it suddenly did. In 1975, the FCC did not have to stipulate that abortion remains a criminal offense. By the way, in the second abortion ruling in 1993, the FCC partly abandoned its previous position. In 1985, electoral law, the FCC did not need to strengthen the right to demonstrate so strongly. After all, for 35 years, it had apparently gone the other way. The constitutional standard on which these decisions are based is therefore not so rigid and unchangeable that it would not permit to come out differently. Such examples show that not only the FCC's decisions are rooted in the political system and are therefore political, but also that the judicial standards depend on the circumstances, which change over time with new majorities, with what is called the political and social change. And we can infer from that a general observation. Constitutional interpretation, as you all know, is not an autonomous legal process, but it is always a concretization of a text under the changing conditions of time. Constitutional interpretation, then, yet, is a distinctive expression of normative knowledge because its success and its effectiveness depend on collective support. Other constitutional bodies interpret the basic law through enforcement. Parliament enacts the law. The law then is the baseline for executive and judiciary action, and those are enforced. Citizens interpret the Constitution simply through the exercise of their rights, and when necessary, through litigation. The fundamental rights and the principle of human dignity are pervasive in an everyday discourse in civil society. Consequently, as Peter Hebele, who many Brazilians will know, has rightly said, consequently, we may consider everybody to be an interpreter of the Constitution. So we live in a society of constitutional interpreters, and it's not interpretation simply limited to institutions. Furthermore, a broad interpretation of the Constitution based on the republican responsibility of the citizen is a central prerequisite to maintain the Constitution's faith. Why should we feel bound by a text that was written, in the German case, in 1949, and that was necessarily grounded on different social-moral ideas? Certainly, one can always amend a constitution, and the German constitution is amended quite regularly. We have had more than 60 amendments, but that requires substantial majorities, and it would be problematic in the fundamental rights sections, which is hardly amended. Interpretation is therefore the alternative to amend a constitution. When we can interpret it, we need not to amend it. Both preserve the legitimacy of the Constitution, but interpretation avoids the politicization of the Constitution, which otherwise would take place through the amendment procedures. The FCC therefore faces a significant challenge in the relationship of law and politics. When may a majority decision shape the law? When may it not? Because it violates the Constitution. When does the law limit majorities, and when does it empower them? Those are all decisions that are basically taken by the court. Consequently, the FCC assumes the role of a guardian of the political process, not only of the Constitution, but a guardian of the political process. The court's task is to conduct a comprehensive constitutional assessment of the political system and its functionality as a whole. It must know when it is wise to intervene and when better leave things as they are. In doing so, it must always produce and present its own decisions as a viable interpretation of the Constitution that maintain a distance from the political decision-making bodies and that refer to the normative standard of the Constitution. However, this standard must remain capable of development. Otherwise, the decision-making standard would become rigid and the FCC would no longer be able to fulfill its role as a guardian. We therefore must ask, how can democratic functionality, context dependency, or impact assessment remain possible if they have to be based on rigid standards from past decades? This is another reason why a parallel interpretation of the Constitution undertaken by civil society is so important, because it prevents our understanding of the Constitution from fossilizing in the form of old constitutional case law. To change an interpretation is, of course, a challenge, always a challenge for a court, because such change raises the question of whether the court has previously ruled incorrectly, which in turn would shake its reputation. Here, too, the task is demanding. Legal certainty must not suffer as a result of too much change. However, if there is no reinterpretation, the legitimacy of the Constitution will suffer at some point, apart from the fact that the political life would be strangled. The fact that the FCC enjoys such a high reputation among the population and probably also abroad shows how well Karlsruhe has succeeded in fulfilling this demanding role. It is hardly possible to overestimate the court's contribution to educating Germans to become Democrats, to exorcising the Nazi spirit from society in the 1950s, to respecting new social movements, to integrating minorities into the political life, and quite general, to establishing a constitutional system of values as a basic consensus, thereby replacing social morality, the moral law, or the natural law in their functions as a basic social consensus. Karlsruhe's success, its reputation, depend on the court's ability to master this dual role, being a court and a constitutional body at the same time. It would therefore not be in the interest of a functioning constitutional jurisdiction if the FCC would retreat to the functional logic of a court and propagate a rigid separation of political life and constitutional law, which sometimes the judges pretend to do. A famous saying from Karlsruhe, many judges reiterated that in the last 10 years. They always say, we only make legal decisions, no political background or outcome. We only decide legally. Yes, perhaps that's what they think they have to present in order to justify their decisions. Now, for the remaining of my paper, I want to address the question, when is judicial activism, something we actually see in the decisions of the Karlsruhe Court? When is it permissible and when it is not? And for what reasons is it permissible? So often the question between judicial self-restraint and activism is presented as an either-or question. Be either on the side of self-restraint or on the side of activism. And I would say the German experience says that the question is, the best should be put differently. It's not an either-or question, it's a gradual relationship. When is it more appropriate to behave in the one way or in the other? It's not a matter of to decide between those two directions, but to balance these and to assess them in their mutual effects. Oh, that doesn't work. Hence, when may and when should the FCC behave in an activist manner, and when should it exercise judicial self-restraint? The decisive question is therefore not whether the Constitutional Court may nullify a norm or act as a substitute legislator, but how to deal with the so-called counter-majoritarian difficulty. And for that question, there are no simple solutions. I try to give an outline of some of those solutions. First of all, it should not be forgotten that the court's main addressee is neither the legislative nor the executive branch, but rather the judiciary, ranging from the local court to the Federal Court of Justice. The vast majority of proceedings in Karlsruhe concern constitutional complaints that accuse the ordinary courts of having violated the Constitution. In relation to the judiciary, obviously, the FCC does not fulfill a political function. Rather, it ensures the day-to-day implementation of the Constitution by the other courts. Here, there is no threat of encroachment on the political process or the competences of other constitutional bodies. However, every constitutional complaint may trigger conflicts between these three branches. This is due to the fact that a constitutional complaint can repeal a law, meaning that the subjective violation of rights results in an objective unconstitutionality. Judicial activism is more appropriate the more likely it is that the minority rights are not only violated individually, but structurally. If, for example, certain views are underrepresented in parliament, as it was the case in the peace movement when this demonstration decision in the 1980s was issued, then it is necessary to remedy the parliamentary representation deficit by strengthening social forms of articulation. This explains the strong position of the right to assembly, which is typically exercised by those who are underrepresented in the political process. However, the political process may suffer from neglecting certain topics due to the inherent rationality of the political process. For instance, the Bundestag has no political interest to reform inheritance tax legislation. Inheritance tax reform is unpopular. It does not win elections. Rather, it alarms strong lobbyist counter-reaction. Finally, the federal government would not even benefit from the tax revenue because the Constitution allocates the inheritance tax's turnout with the states. However, inheritance tax law is a central element for equal protection and against the exacerbation of wealth inequality. From the point of view of forcing the Bundestag to deal with an issue that is important for society as a whole, it's a matter of social justice, but does not promise any political return. It was correct that the FCC repeatedly objected to the Inheritance Tax Act and required the Bundestag to deal with this issue. So that would be a case where activism is absolutely justified because there's no inclination of the political process to embark on these issues. Here, the FCC fulfills a stimulating function and prevents the political process from becoming bogged down in working through coalition agreements agreed on for 4 years. The effect of such court interventions in the political process is similar to that of a popular initiative. In this respect, the FCC also compensates for the lack of direct democratic procedures at federal level in Germany. Now it's only 3 more minutes. Yeah. 1 page. In the FCC, if the FCC sets topics and allocates political duties, there is a significant risk of encroachment on democratically accountable legal policy. Here, it is advisable generally for the court not to decide too much, which means either allocate a task, the reform of inheritance law, but then leave the means to the legislator. Don't enact too much. In some instances, the court has gone too far in specifying the means, for example, by linking the reform of inheritance tax law to very specific and detailed requirements from the principle of equality. Another case would be the abortion ruling, where the FCC also went too far by creating a new protective duty and simultaneously specifying the means for implementing the duty to protect. Criminalization, indication with the very narrowly room for maneuver for the parliament. As a prudential rule, there must always be something left for political responsibility and thus democratic legitimacy and sanction, either the goal or the means. Both must not be decreed by the court. The court should either decide the goal or the means, but never both at the same time. In this way, one can trade off activism and restraint quite well, and at the same time trace the trade-off back to constitutional requirements. In essence, the FCC is called upon to engage in democratic activism in 3 constellations that can be generalized. Namely, first, when there is a deficit in representation, John Hart Ely's case, so to say. Second, in order to protect structural minorities that have no chance of winning a majority, new political parties coming up, the Greens before they were represented in the Bundestag, cases like that. And third point, when the political process threatens to petrify. It is also worth considering other potential scenarios that could justify activism. If there is a majority consensus that certain competences are being eroded, for example, self-executing laws as the federal emergency brake, which then curtails the jurisdiction of the administration as well as the courts, that would, in my view, also be a justifiable case for activism. Another example would be when competences are shifted from national to European bodies, and the case law may further develop in reaction to future solutions. Unlike decisions concerning rights in individual cases, the FCC's decision in the democratic realm are never the last word. If the FCC decides as a constitutional body and not as a court, then of course the same applies to it that applies to other constitutional bodies. There is no last word. Democracy is based on the opportunity for the minority to become the majority, and then change things. Democracy thrives on revisibility. It is therefore important that the democratically relevant decisions of the FCC remain open for interpretation and reinterpretation, and do not themselves contribute to the petrification they wanted to solve. Constitutional interpretation develops into the interpretation of interpretations. Only the political function of constitutional jurisdictions makes such a discourse of interpretation possible. In this perspective, the FCC does not become the governors of democracy, but the father of constitutional patriotism. Thank you very much for your attention.
Thank you so much, Oliver. Any questions? I propose we take 3 questions together at a time, and then yes, I have here in the front, I have Nils Jansen, and I have please. Nils. Oliver, there's one more question, I think. Please. So I've seen lots of more hands. I propose that we first give Oliver the floor, and then we see whether we still have more, whether we have time for more questions.
Thank you for very interesting questions. The time frame requires that I be brief, unfortunately, but we can have closer conversations afterwards. The European perspective. Thank you very much. That's a most interesting question. I think when the court decides, it never pays attention to what how its own decisions will be reinterpreted by other courts. At least it did not for 70 years. That may change because now the court is very eager to have its own decisions translated into English, so it wants them to be read by others. So this indicates that there is a change. But, you know, that's a very recent development. I'd say we are talking about the last 10 years or so. On the other hand, if you look who is appointed or elected to the constitutional courts, I would say those judges are, I don't want to be unjust, but they are rather German trained and German focused, experienced lawyers. They don't have a very international background in general. So on the one hand, they want to be read broadly and on a European level. On the other hand, they themselves have a rather national mindset, I would say. There are some exceptions, of course, but as a general outline, I would say that works well. Niels's question is yeah, very fundamental. Well, let me make my point a bit clearer, perhaps. We have, if we decide between two areas of decisions, we have rights decisions and we have procedural decisions. The rights decisions often refer to individual rights, constitutional complaints. It need not be so, but that's mostly the case. And the procedural decisions, they come out of norm control or federal state issues. It need not be that, but for a general rule, that works well. So now the interesting thing is, when is a rights decision brought up, not by individuals, but by other constitutional bodies? And that was the case in abortion. That was never a constitutional complaint. It was always, yeah, yes, because the unborn child cannot bring a constitutional complaint. Yes, yeah. But it was no constitutional, it was not an individual rights case. It was a procedural issue. Yeah. And now that's interesting. So do we expect the court to come out very strict in rights issues when the rights case is not brought forward as a constitutional complaint, but just by the opposition? Yeah. The abortion case is the opposition, Catholic, Bavarian opposition, yeah, denies the reform law. And it uses the court to increase the viability or the validity of its own arguments. Yeah. So that's the political situation behind it. Yeah. And I would say in that case, it is not wise to have an activist rights jurisdiction when at the baseline of the conflict, actually it's a majority issue. That would be my answer in that case. The question, how maybe that answers also a bit your question, yeah? When we can adjust more procedural issues or more rights-based issues. And don't underestimate the restrictions that come from the constitutional procedural law. Yeah, because there are different claimants, so to say, before the court. Sometimes it's a citizen, but sometimes it's the opposition. Sometimes it's a federal state. Yeah, so it's on the federal level. So the claimants are very different, and it's not just a matter of material or substantive constitutional law, yeah, that then gives us an idea how the case could come out, but also who is the claimant, what is the relevance of the substantive law for the process on the one hand, or for the restriction of rights on the other hand. And I just want to present that in order to show that we should not expect too much unity in the outcomes of such cases. Yeah, that they come out differently, sometimes more restrictive, sometimes less restrictive, and that has something to do with the context of the case, yeah, and the claimants that bring the case before the court. Often the jurisprudence is too much concentrated on substantial issues and then underestimates the relevance of procedural requirements. Yeah. Now, why is the court so successful? Maybe it is because it never acts explicitly as a political body, and it evades the word political. Yeah, it shies away from that word. I briefly mentioned this quotation that many judges reiterate every other week. We do not decide politically, we only decide legally. All experts know that's kind of a fairy tale, but it might be very good in convincing the public that the issues are decided on a different scale of values, on a different rationality. Those are legal decisions, although we as experts know how much they are influenced by political underpinnings, context, and majority-minority issues. So my answer would be, in order to sell a court and to create a reputation, to foster esteem, it is, at least in the cultural perspective, a good option to refrain from presenting the own institution as a political body, and always to stress, no, this is legal expertise. It's a legal judgment. Yeah. Perhaps that's the difference to the Brazilian case, where your constitutional judges, you know that much better than I do, and Conrado quotes on that every other week. Yes, they are sometimes disguised politicians. So in Germany, the population doesn't know the names of the judges in general. If they know the name of the president of the court, that's deep knowledge already. Yeah, and the judges don't want their names to be known in the public. Yeah, for exactly that reason.
Thank you, Oliver. So I saw that there was a lot of interest. I think we have already run out of time. So we have lunch afterwards. So maybe that's you think? Okay, then we make one more round. So I have Virgilio, I have Leonor, I have Pedro, I have Conrado. Okay. Very brief, please. Yes.
I don't know order that debate. My question is that most cases if you find the rule very narrow, unless you just very broadly, so legislation should do better. Then you have discretion. Otherwise, finding the goal is almost the same. And very quickly, what extent the nomination for the members of the court contribute to the ability to form the text the past. to happen severe consequences. And we see this what yes, only has a political right. How can we deal with it? Because we have any knowledge of the provide to show the how to very difficult about exactly. And also, secondly, it's actually what said by the law about being saying that aspect recommendations about when, how do the intellectualism going on. That's very difficult help. Very, of course, collectivism. Very good. But it's also some other questions. And nothing to do with that. Things you have to be for the fact. Finalize.
I know, Oliver, you could spend 45 minutes on answering these 5 questions, but we have 2 minutes.
Yeah, thanks again for this great great bunch of questions. Virgilio, you're absolutely right with pointing out that goals and means are related to each other. Yeah. Keep in mind that goals and means are intertwined in the general requirement of proportionality review. Yeah, so that is a standard that the court applies quite regularly, proportionality review. And within the proportionality review, there is first the issue of what are the goals, and then the second issue is how are the means appropriate in order to pursue these goals. So we have a case law experience of 50 years in bringing goals and means together and see all the interrelation between the two. So my argument, in a way, presupposes this standard of review, the proportionality review. So that may further explain why I then, since proportionality review is applied anyhow, I make this distinction. Yeah. Yeah, self-restrained, and now I have so many notes and I cannot really assess the notes to the speakers anymore. Self-restraint is a procedural requirement, or yeah, I should say, self-restraint is not just an issue of substantive law. It also is an effect of procedural requirements. However, in the comparative constitutional law cases, we rather get the impression as if it was an issue of substantive law. I don't want to deny this. I just want to open the eyes for the procedural requirements that are behind the court judgment. And there are much stricter procedural requirements in Karlsruhe than there are in Washington, D.C. In Washington, there are basically no procedural requirements. They decide what they want to decide. And that's not the case in Karlsruhe. They have to decide. They cannot simply say, there are 500 cases brought before the court. Those are the 60 we want to decide. They have to decide every of those 5,500 cases brought before the case annually. And hence, they create procedural requirements to limit the caseload. Otherwise, it would be like in the European Court of Human Rights in Strasbourg, tens of thousands of cases. And by bringing up such procedural requirements, of course, the court, with the idea of limiting its caseload, sets up procedural requirements, and these then affect substantive law. So this is an interesting effect. And I just want to emphasize again, we have two major procedural requirements that are not known to other courts. That is constitutional complaint on the one hand, and it's abstract norm control by the opposition on the other hand. So those are very interesting ways to bring a case before the court. Whereas concrete norm control is rather traditional means, other courts say this is, so I'm not talking about that. And my point would be then when we adjust to activism, restraint, we should take into account the procedural background of those cases. And if we take that into account, we necessarily have to take into account, in the case of the abstract norm control, the role of the opposition. Is that really a minority case? Yeah. And to what sense does it affect the political process? Was there injustice, unbalances in the political process, which then would incline or increase the inclination of the court to step in? Or is it, so to say, the opposition has no minority and it looks for overcoming their minority position by bringing the political issue before the bench in Karlsruhe? Then rather the court would say, no, we leave it to the political process. What would be a solution for Brazil? Well, I'm the least person who is able to give you such answers. But well, what do you think of that proposal? We need other interpreters of the Constitution. If the Constitution is only interpreted by, how many are these? 15 in Brasilia? 11. Why limit the range of constitutional interpreters to 11? Those are the 11 that decide. But deciding an issue does not mean those are the ones that those are the only ones that interpret. Bring up other interpretations. Bring up a plurality of interpretations. If these 11 are very pluralistic, well, so is society, so is academia. It's up to the professors to comment on these interpretations, say, this is not convincing. Yeah. If the court in Brasilia is acting too politically and too little, or too not in a strictly legal sense, well, we are the lawyers in this room. We should bring up other interpretations and say, this is a different interpretation. And now choose, which do you think is the better one? Of course, the Tribunal Federal has the final word on that case, but not on the interpretation. Yeah. Now there are many other issues. Conrado, I think we discussed that afterwards, individual, because that's now the answer would be too long, and Niels is looking so angry from, I see him in my left eye angle, and so yeah. Perhaps the last word on the question of the nomination procedure. That was a huge mess now in the last 2 months in that case. Yeah. Don't overstate that. Nomination procedure is very interesting. We actually don't know how judges are nominated to the court. It's a miracle. And sometimes it's just by chance. Nominations come by surprise, I would say. And there's only a very limited number of highly ranked political personnel in Berlin, and they depend upon their personal advisors. And this has to do with structural reasons. If one needs a federal judge, you know, there's a minimum requirement. There's a minimum requirement of former federal judges, and no politician knows any federal judge. Yeah, how should they? But no politician knows any law professor. Yeah, why should they? So what the candidates they know are probably former politicians, and we actually have former politicians in the court. They must be lawyers, of course. But if they look for a professor, they say, well, we have 8 judges on the bench. 3 should be professors, 3 should be judges, 2 should be politicians, as a basic rule of distribution. Then they say, well, now we need a professor. Who knows a gifted professor? I mean, and the selection then is by chance, I would say. And the same is a bit with the federal judges. So there is no mastermind behind the process. And perhaps that's a good thing. It's just nomination by chance. And we only can say, with the record of 75 years of experience, this miracle-based nomination somehow turned out to be fine. No, it's the mixture is good for it. Don't have too prominent judges. The most prominent law professors hardly make it to counsel. It's more a little above average, I would say. Yeah, not the most prominent ones. And the same perhaps applies also to the other candidates. So there is a tendency for a mediation, compromising candidates, no radicals. Yeah, so let's say it's on the whole a bench of individually, I would say, rather boring people. You don't want to spend a dinner table with them. Yeah. So that is my impression, because they are very, so to say, I mean, they are not very outspoken. Yes, they are modest and yeah, I shouldn't go into it further. Yeah.
I definitely want to sit next to Oliver at dinner. So so thank you so much, Oliver. I think that was a great start, and you could see what the lively discussion you inspired. Now we go on to Ronaldo Portomacedo, who is legal theorist, legal philosopher? In which camp are you? So, and who will talk about what Wittgenstein has to offer to legal theory? Ronaldo, you have the floor.
Okay. Well, thank you very much, Niels. My talk is about a very broad issue, and I have very little time to talk about this very broad topic, which is what Wittgenstein has to offer to legal theory. My main task here is basically to spread some ideas. It might look very much more like an agenda than really clear, well-defined arguments in support of my claim, but it's a kind of agenda in many ways. So let me start. Wittgenstein's thought have been a fundamental source of inspiration for the 20th century legal theory. From his influence on the intellectual environment of the Vienna School on logical positivism, and to a certain extent on Kelsen's idea through the impact of the Tractatus and the Vienna School, to the incorporation of his vigorous criticism of the concept of rule he developed in the first part of the philosophical investigations, and especially in the Blue Book, that profoundly marked H.L.A. Hart's ideas, for example, in the concept of law. Several works on Wittgenstein and law have been published in the recent decades. However, only in recent years have the impact of Wittgenstein's philosophy on moral thought and the manuscript on certainty occupied a central place in the academic reflection. This work explores the paths that the last phase of Wittgenstein's thought, in particular his concept of hinge epistemology, offers for understanding the legal epistemology, presenting some solutions, I think, to overcome some classic debates between universalists and relativists, foundationalists and contextualists, as well as offering new venues for rereading some of the contemporary authors, such as Dworkin and many others who are at the center of the Anglo-American debate, but I think has also impacted German culture. Okay, so my point here is I'm trying to narrow. I'm not talking here about everything that Wittgenstein has to offer to legal theory. He has already offered a lot. He has already produced a big impact in the, for example, impacting the work of H.L.A. Hart. I think he set a new agenda that is usually linked to the impact of the linguistic turn in legal philosophy, and he is one of the major key figures on this. So my point here is much more focused on what else could Wittgenstein offer to legal theory beside what he has already offered, especially through the impact his work has had during the 60s and the 70s, and which is so this more recent possible impact. So it's interesting to notice that in the past, Wittgenstein's thought, particularly his ideas presented in philosophical investigations, first manifested in philosophy of language and logic, later expanding to epistemology, and only much later to ethics, and even later to law. So there has been some kind of progress here. The same trajectory is being followed by the impact of Wittgenstein's later works, particularly his book on certainty, written between the 50s and 1950 and 1951, and only published in a bilingual English translation in 1967. So it's a pretty much recent work for the audience. The relevance of this text and others published after philosophical investigation has attracted much attention in the philosophical world. Many have come to see in it a kind of third Wittgenstein. Wittgenstein is well known for presenting two different philosophers, the first and the second Wittgenstein, and some people now are even claiming that there's a kind of third Wittgenstein. So although it seems exaggerated to me, it's, I think, indicative of the novelty contained in these works, and especially in this little book called Uncertainty. Initially, the debate generated by uncertainty was limited to philosophy of language, and then later to epistemology, and only more recently has it been expanded to reflection on ethics and law. However, this last period marks a new frontier, or at least an exploration of a philosophical field with original ideas and some small nuances, also with new categories, with new philosophical tools. So we have a new that gift from the toolbox offered by Wittgenstein to philosophy in general. These define the thematic field, which is sometimes also referred as hinge epistemology. That is an epistemology of axes and hinges that constitute important categories for reflecting on uncertainty and on language game or language games associated with the action of thinking. Despite the existence of pioneering books on the subject, I still believe that this is one of the most important and new frontiers of research on linguistic turn and its connection with legal theory. So, in this little book, Wittgenstein starts with a reference and a kind of a position with some statements, philosophical statements made by his friend and colleague at Oxford, the famous philosopher G. Moore. So, let me set the big novelty, which is at the very center of this little book. Philosophical debates on the notion of moral certainty have their roots in Wittgenstein's more general discussion of certainty, found on these notes, which is published as a book on certainty. And in these notes, Wittgenstein begins to sort through the various ways and contexts in which we manifest certainty, give its height, or things that, according to him, stand fast first. Fest. I think it's the same. It's easier to translate into English than to Portuguese. That comes fast, come directly to us. Now, what is he looking for is something different from a mere assurance, considered as a psychological status. Taking his lead from the work of Cambridge contemporary, and especially his friend Moore, Wittgenstein considers Moore's claims that he knows that he has two hands. So this is a famous example. Moore said, I know that I have two hands. And since I know that I have two hands, I know that I can prove the existence of the external world. So he starts from let's say, a platitude, something that he claims to know for sure, to the next step, which is so that thus I can say that the world exists. So in this proven existence of external world, Wittgenstein observes that the use of the word know is inappropriate in such a case because, for one thing, knowing implies the possibility of verification. So on one hand, what Wittgenstein claims here is that Moore was right in confronting the skeptics when he said that it makes no sense to doubt that I have two hands in that specific context. It would be, something, a nonsensical kind of doubt in this context, because it's obvious that there are two hands here. On the other hand, he criticizes Moore for taking too fast a step further in saying that thus, for this reason, so I know that the external world exists. So the second step was a kind of non-allowed, illegal step towards his conclusion. So Wittgenstein said in Uncertainty, if a blind man were to ask me, have you got two hands? I should not make sure my looking. If I were to have any doubt of them, then I don't know why I should trust my eyes. For why shouldn't I test my eyes by looking to find out whether I see my two hands? What is to be tested by what? So in this very short passage, what he claims that there might be some context in which it could make a lot of sense to doubt if I have two hands. If I'm hospitalized, I have been under drugs, very potent drugs, and I might have a doubt if I have made a surgery, if I still have my hands, because I'm not feeling it. So there might be special context in which it might make a lot of sense. Or if I say I have two hands and there's a blind person in the audience, he might doubt this. However, if he doubts this, this is because there might be something that impedes, let's say, the normal verification of the truth of this situation. For example, if I'm not blind, I'm lacking the possibility of directly verifying this. However, in other contexts, I mean, to say that a doubt that I exist will be nonsensical, because it will be as logic as doubting the capacity of my eyes to see. And a further step of this kind of challenge is, I think, a very powerful claim against some kind of Cartesian, radical, hyperbolic doubt that Descartes showed in his works, especially in the metaphysics. Because, I mean, we cannot doubt everything at the same time, because if we do that, it will be nonsensical even to give some kind of meaning to the very practice of doubting. So in this sense, doubting requires some level of certainty that cannot be justified. So we start our beliefs not with everything that we can justify. So the issue here is that there is a kind of special relationship between our claim to justification, which is a central concept for legal theorists and lawyers, of course, and the idea that there are some basic beliefs that cannot be justified. And the issue here, again, when we bring all the discussion to the domain of ethics or moral, is, are there basic moral beliefs, basic moral hinges that shouldn't be justified, and it will be nonsensical even trying to justify them. So, as in the case of having two hands mentioned by Moore, we seem to know that the wrongness of killing, that's our torturing babies, or killing for fun, in such a way that further explanation and justification of it seems out of place, if not impossible. Nonetheless, as Nigel Pleasance, who is one of the authors who explored this venue of applying or using Wittgenstein's ideas on certainty in thinking about ethics, even as Nigel Pleasance points out, many philosophers had tried and continue to try to explain the wrongness of killing. Kantian version or utilitarian version, I mean, trying to explain why the wrongness of killing should and could be justified universally, on the idea of category imperative or the idea of principle of utility. There are many more, let's say, religious or traditional natural law perspective, trying to justify it or to say why this is so, why this is wrong, why killing is wrong. However, after surveying some philosophical or many philosophical explanations, Pleasance concludes that they amount to no more than a gross pseudo-explanations. Such theories are either tautologies dressed up as explanations or utterly banal statements on the blatantly obvious. So that's the challenge put by Pleasance against this kind of radical foundationalist perspectives on morality. So we seem to have a philosophical impasse. Our most deeply held moral beliefs, surely the wrongness of killing is such, cannot be explained or justified. We cannot give reasons for holding them, so we cannot give reasons to act on them. This result seems to be more than purely philosophical import. To be sure, we can and do get along morally without posing or answering these difficulties about the explanation or justification. So the notion of basic moral certainty, for some of those who write on it, provides an explanation or dissolution of the seeming paradox between unjustifiability of our basic moral beliefs and their unshakable certainty. So we cannot justify, but they are certain. This is a kind of the idea that we have to address. It does so in a way that does not depict basic moral certainties as words that have mere psychological force, but by showing that our practices and language games in which you talk about and react to wrongful killings are beyond the possibility of doubt. So now I'd like just to map some 4 debates, which I think come from this idea or this challenge to some kind of classical skepticism that Wittgenstein was trying to react against in this book, uncertainty, and also some reactions produced by those who, in fighting the skeptics, try to offer a more foundationalist, a more fully grounded, let's call it this way, reaction of philosophy of moral. And for this reason, I tried to map 4 debates on moral certainty and some agreement amidst the controversy that is raised on these debates. First, about the idea of the wrongness of killing. Much of the debate on moral certainty has so far centered around the key example of wrongness of killing. It seems that if we are certain of anything in the moral world, the act of killing is taken to be justified in some circumstances. For example, if it is the only way to defend oneself against a lethal attack. There is a debate over whether killing embryos or non-human animals is justified. But such debates presuppose the fundamental wrongness of killing in the absence of justifying circumstances. Or perhaps it's better to say that we, whether at the cultural or simply the human level, have some shared certainties around the wrongness of killing. These responses have focused on doubt about the scope of this certainty. Do all human societies share this moral certainty? Its generality, it is right to say that killing as such is wrong or only in a specific context. That is to say, both the extension, tension, and the content of these putative moral certainties are usually at the center of the moral debate. Yet, this uncertainty about boundaries and possible outliers should not draw our attention away from 2 fundamental facts. Unshakable certainty over the wrongness of killing is at the core of our moral selves, and most humans take it in some form for granted. Nevertheless, there is no culture in human history that has not had some prohibitions around killing and has not taken them seriously. So the point is there, even if we take the idea that, well, it makes no sense to say universal, that it's wrong killing. Most of our human cultures are structured in terms of this statement that it's wrong to killing for fun or something like this, and then with some exceptions. And it seems that no culture, no human culture has ever been indifferent to this idea that protecting life or the wrongness of killing is at the center of it. I could expand, but I want to just mention another example that is usually at the center of this philosophical debate, which is the very meaning of a promise. So the idea of our moral obligations to fulfill a promise seems to be directly connected that whenever we break a promise, we have to have some kind of justification for it. Or as Thomas Scanlon, for example, mentions in a very, I think, savvy way, he says that promises would be rendered meaningless if we were allowed to break them for any reason whatsoever. So the idea that the very concept, that what do you mean by promising, requires the acknowledgement that promises are there to be followed, and if we are to break them, we have to justify this break. Okay, so a second debate, a second agenda that is set by this debate on hinge epistemology is related to the opposition between universalism and relativism. Do we all have the same certainties? This is at the center. Relativists trying to stress, no, what is right here might be wrong beyond the Pyrenees. So this is a classic way to see that we have a lot of sociological changes. Conventional morality is obviously different and varies a lot from place to place. So the second debate to be identified is about the extension of moral certainties. Do they hold for everybody, or are they all relative to in some sense? While some authors take some objects of moral certainty to stand fast for all morally competent agents. So this is one trend, this is one possibility. Understanding moral certainty as an epistemological hinge, something that I believe that would make no sense to doubt, and take it as something that is universal. This is, for example, a way of understanding that is supported by many natural lawyers. Other regard all of them as relative to particular communities at particular times and places, and greatly variable in what does and doesn't count as wrongful or legitimate killing. So this would be the other alternative. It's always relative. Killing is not wrong. I mean, if someone is asking you to help in his euthanasia, killing would be the right thing to do. So I mean, to say that killing is wrong is merely a very, let's say, problematic or a very vague idea that would make no sense at all. Other authors explored, and this is a track, I think it's a very fruitful one, explored, and one example of this track is taken by a British philosopher called Daniel Moyal-Sharrock, who says that, well, then we could think about mixed models. We could think that there might be, at some level, some universal hinges, always being very careful in understanding what we should call as universal. Universal is not really ahistorical, but something that is usually applicable or meaningful in such a broad plenty of cases that we should maybe use this idea of universality. So it's not a logical universality, but it's a more broad range, such as, for example, it's wrong to torture babies. Why it's so broad? Because, I mean, someone who denies this as a Cartesian doubter could say, why is it wrong to torture babies? This will call our attention for discredit the moral competence of this person who is really, let's say, authentically, genuinely doubting that it's why should be considered wrong to torture babies. And there are other certainties that are more, let's say, context connected, that would make a lot of sense and would function logically and linguistically as hinges, something that will make no sense to ask for justification, but are not so universal, or less, let's put it this way, universal. So it would be much more like a matter of degree. Just to take an example, nowadays, according to in the context of modern contemporary constitutional law, to ask why it's wrong to slave people would be as silly, or would sound as meaning as nonsensical as asking why it is wrong to torture babies. However, if we take the case from a historical context, it would make a lot of sense. It made a lot of sense. It was not nonsensical to ask why slavery was wrong. I don't know, 300, 400, 500, 400 years ago, or even less here in Brazil, for example, or why it's wrong. I think to take why it's wrong not to treat women equally. Well, it's nowadays in many contexts considered something that's like a hinge. If someone asks why should I treat women equally, you say, well, this is nonsense. I wouldn't even continue a conversation with you. However, in many more closer contexts, it still make a lot of sense to discuss and to debate this. So in many contexts, it would make sense to ask for justification and to offer justification. So hinges are context dependent always. Okay, I think this idea or this contrast could could put some light in our in the possibility of revisiting old debates, like, for example, the debates between that are famous in epistemology in general, in moral epistemology, and nowadays also in law, between foundationalists and contextualists. I think so. For example, Kantian kind of approach, which is still very much foundationalist, or utilitarian approaches, which are clearly foundationalist, and skeptical or social relativist approaches, which tend to be extremely at the other side, saying that it's always contextual. So I think that Wittgenstein's ideas here could offer a kind of a more interesting, rich third path in order to understand that it's a kind of philosophical mistake that lies behind the way that this debate has been traditionally framed and put into work, and also how it has been received by the legal debate. Okay, so let me go past the end of 3 minutes. Okay, so that's more than enough for my conclusions. Okay, so I think that revisiting this, picking up some of these philosophical tools from Wittgenstein toolbox offers us new perspectives for reappraising old theoretical debates. I mentioned some. I could also mention others. I think that some of these perspectives have already been explored by some authors who have had some influence by Wittgenstein, some others who were not even maybe not directly influenced by Wittgenstein, but have followed, let's say, a parallel track. And whenever we realize this, it's also another opportunity to refine our analytical tools, try to compare how different perspectives arrive to similar conclusions. I mentioned previously, for example, Thomas Schelling works on promising. He is far from obvious that has been deeply influenced by Wittgenstein. Of course, he's a very erudite person, has probably read, or even Ronald Dworkin, he quotes sometimes Wittgenstein, but it would be excessive, I think, to say that he is a Wittgensteinian in full-blooded Wittgenstein. The ideas are parallel, but I think that whenever we could organize these debates on using these tools, we have something to gain. Another philosopher who has been recently rediscovered, or which's importance for legal theory has been reappraised, is Bernard Williams, the British philosopher, moral philosopher, whose ideas have been explored on its impact on legal theory, and he has going really to the end of it. He has proposed a way of describing this kind of third possibility between extreme relativism and extreme contextualism in what he labels for his own philosophy as relativism of distance. A phrasing that I prefer to describe this perspective, which I think it's very clearly supported by, not very clear, but it's supported by a sound interpretation of Wittgenstein. Everything in the Wittgenstein is also very debatable, very controversial, which is the perspective of a perspectivist without relativism, which is something I could talk more in the debate if you want. And also, I think this also shows new perspectives for understanding that moral certainties and legal certainties, for sure, they are not grounded exclusively on our linguistic practices, but are grounded on our form of life taken as a more broad concept in the way we behave, in the way our emotions come into have a very important role in our moral beliefs, which I think it's another very interesting perspective for reappraising, for revisiting the traditional ways in which moral grounds or moral justification have been brought to the legal debate. So this last topic is what could be labeled the idea that our moral certainties are not exclusively propositional certainties. It's not exclusively certainties based on the way we reflect and the way we think, but also are grounded in the way we behave, in the way we feel, in the way our attitudes are grounded in our human way of life. I'll stop here. Thank you.
Thank you so much, Ronaldo. So we do it as before. We bundle questions. James.
So it is exactly 20 years since I read it. So I want to ask the question that one really most people but I want to invite you to apply what we have to say to the conversation that we just had between one of our other politics. So we can think of this distinction as we think about it, we think about it in the same kind of terms, but we don't actually have reason to verify the distinction. And we can have reasons without by moral, that we right. But we have actually known that it's verified. We might not even verify if we had the very test that even does. You might wonder if he does. So it seems like a good example of that kind of term. And similarly, it seems like a good example of a term where it's very tough, where it's a game. And we agree to play the game, we agree to treat the distinction with more certain ideas, or we refuse to, as some part of the So I wanted to ask you to explain the argument with my all moral certain things that I know with that discussion.
Someone else? Otherwise, Ronaldo. Oh, yes, please. And
Is it or an actual and when we take this lens to tolerate this relation, we underestimate similarities that are important. I would like to kind of follow this.
Thank you.
Okay, well, thank you very much for the very interesting questions. Let me say first something coming from the related to the last question, which is whenever you ask how could Wittgenstein offers us some kind of method to dealing with this? What is universal? What is local? What are the values we should accept as applicable to this context and not to that? Well, first of all, we have to remember that one of the major, I think, novelties and the strengths of Wittgenstein's idea is to challenge this the idea that we could ever think of a possible answer to a question framed this way. So, I mean, because it's in many ways it is contextualist. So the idea is that we wouldn't find a better definition of a universal rule. That would be like, say, the shared mistake by deontology, Kantian deontology, and utilitarian philosophy. There are two philosophies, opposite perspectives, fighting for how best explain the golden rule that would serve as a method, as the universal method for understanding what is right and what is wrong in different contexts. This is what I think Bernard Williams addresses very interestingly in his works, deeply, I'd say, influenced by Wittgenstein, in showing that these two perspectives try to know what is the method, in singular, what is the rule. This perspective shares the same common flawed assumption. That's the reason why he labels it morality. So it's a special way of thinking about what is right and what is wrong that is structured as if morality could be seen by the God's eyes, some kind of imitatio Christi, some imitation of Christ's perspective in addressing moral issues. So what is then left? and I think this is connected to this something that I simply, a slogan I simply raised: perspectivism without relativism. What do I mean by this, and what does Bernard Williams means or intends to say by relativism of distance, which I think it's a parallel idea? It's the idea that, well, of course, that Wittgenstein's investigation is about the possibility of meaning. I mean, in which context is it meaningful to ask or to require, to demand justification? So what is the logical grammar of the way we use the moral language that will allow us to take a proposition that, according to the Portuguese grammar, the German grammar, is perfect, but that would be a flawed or a nonsensical phrase from a logical perspective, from a logical interpretation of it. So what happens here is that what is the result of this? Is that, and this is what I very quickly try to say, is that some questions, I mean, the question, is slavery wrong? Or is, do you know that I have a hand? Or do I know that I have a hand? In some contexts, these functions as a hinge. But I mean, the problem with Moore's claim is that he tried to say that because he knows that in this context, he can take the statement that there is a hand here as a hinge. He could then say, he could then universalize this and say that, then I know that the world exists. So this is, let's say, the unlawful, this step, which is try to universalize missing or missing the attention that there has been a change in the language game, in the way, the structure of the production of the meaning. When we generalize as a let's say, a scientific statement, the world exists, this is different from the conditions of meaning that are at stake when I say in a private conversation. And that's the reason why, I mean, to say that killing is wrong is not to be understood as a universal, a historical, a contextual, basic moral belief. This would transform Wittgenstein's novelties into platitudes. It would transform him into, I don't know, a natural lawyer. Traditional, this is not what he said. He's not claiming this. He's not John Finnis on this aspect. So what he's claiming is that there are some contexts in which we have to pay attention and to check whether we are asking for justifications for what would be nonsensical to justify. And what is the usefulness of this? The usefulness is that we'll stop wasting time into trying to find the universal justification, which is a common trend among lawyers and moral philosophers, and we would rather, it would instead replace it with a more subtle understanding of what is at stake in the context in which the demand for justification is raised. And this, I think, is very much connected with what you mentioned. Of course, in political context, it would, rhetorically, it might sound very powerful to say that one claim is a hinge. So instead of saying that this is a basic moral certainty, I'll now make it express it in a more fancy way, philosophical. Oh, this is a hinge. Oh, but what is the point? I mean, of course, there might be some rhetorical weight in expressing this way, but it would be a violation of the very idea. It would be a philosophical mistake, simply trying to say that, well, this is so basic that cannot be challenged, just to add some rhetorical force, some rhetorical usefulness for this. But of course, I mean, in many contexts, especially in law, the political interest or political dimension of language is also at stake. So, of course, in many contexts, someone would say, well, slavery is, if slavery is not universally the basic hinge, something, then what could it be? And here I was not claiming that slavery is not, is even a little bit less, let's say, less heinous, less abominable than killing people. I'm just saying that I was just trying to show that this varies according to context. And in many contexts, the requirement for justification, which is at the core business of lawyers, or core business of judges, is not something that would be sound to look for. It would be meaningless. And on the other hand, there are situations in which people would possibly claim, well, this is a hinge, when there's no hinge at all. It is something that has to be justified. So how to separate? What is the method? There is no universal method anymore. You have to make an analysis of the specific language game. So this comes with some kind of training instead of from some, let's say, universal method. There's no such a method. The method now is that you have to train your capabilities. So this, in a way, brings philosophy and philosophy of law in particular into the understanding that this is a practical philosophy, the practical dimension. It's not exclusively theoretical if you think theory in its classical meaning as describing something from outside, but it's something that is intertwined in your practice. But I could talk more about this. Stop here.
One last question. And then I think we take 5 minutes break.
Yes, for the coffee, otherwise. Yeah. Okay, great question. That would bring us to other, I think, possibilities and strengths of Wittgenstein's philosophical claims. One is this, I mean, his rejection for, in a very interesting and complex way, his rejection of the scientific method as a valid method for philosophy, for language analysis, and the myth of this, let's say, commitment that the scientific method would be the only rational method for linguistic analysis. So this comes together with a rejection or a deep, let's say, epistemological stand against this way of making philosophy. His very strong reject opposition, for example, with the Vienna School idea of trying to export scientific method as the method valid for most of the sciences and rational thinking. And again, this has some spillovers against, for example, this Kelsen's project and many other legal theory projects in the 20th century and 21st century. Just a final word about ethics of virtue that I missed, that you mentioned. Yes, of course. I mean, Elizabeth Anscombe, who was a former student of Wittgenstein, she was one, I think, who first raised this flag for the importance of attitudes, for practice, for the way people ground, or let's not say root, their basic moral beliefs in their form of life. So in the very famous article, the modern moral philosophy, very small article, she raised, I think, this flag. She started a movement, and I think Bernard Williams was the follower of the same path, deeply influenced by the same ideas. I tried to condense, to abridge in a very let's say fast, quick way here. You are right. This is where things started. I wouldn't say that this necessarily means that Aristotelian virtue ethics is the only match, is the only fitted possibilities, but this is the kind of match that we can find somehow in Anscombe and more. I don't think this is the kind of match between ethics, virtue, and all this debate that we can find in Bernard Williams and in many other philosophers. So this is just one possibility of rereading ethics of virtue under with the light, with a little help from Wittgenstein's. Thank you.
Thank you so much, Ronaldo. I would propose, maybe instead of taking a real break, that we take 2 minutes, everyone gets a coffee, and then we continue with. So that's really just 2 minutes. Who wants a coffee can get a coffee. Who wants a water can get a water. So the coffee is that's he's the next one. I will give it to him. Thank you so much. Yes, yes, I'm handout.
Na, liegt das am besten?
Let you down.
Ah, sorry. Gute Weile, liegen jetzt aufeinander. Und der wichtige Frage wurde ja, nee, natürlich. Aber da war aber auch eine Frage, und dann waren die Brasilianer ja jeder Bund was zu erreichen. Aber eben also
Okay. So I propose that we continue because we're already a little bit behind schedule. I'm German, you know, being behind schedule makes me nervous. So those of you who haven't gotten a coffee yet, do it quietly, but I propose that we start. Let me introduce Nils Jansen to you. I introduced him earlier as a legal historian, but I think he's a good fit on this panel because he's not only a legal historian, but he actually started off his academic career not as a historian, but as where would you put yourself, as a legal theorist or philosopher?
Well, I leave that open.
But he will talk about codification, politics, and legal science, historical observations at the 125th anniversary of the German Civil Code.
Yes, thank you very much. When I spoke to Niels about the title of my presentation today, what I had in mind actually was to present to you the core ideas of a 50 pages paper I just published in the Archiv of the Zivilistische Praxis, in a special volume on the 125th anniversary of the German Civil Code. Now, when I learned that I should not speak longer than 20 minutes, I realized that I would have to focus a bit more and to concentrate on one important point which might illustrate the main thesis of this paper. I would therefore speak about the attitude of German legal scholarship, what we call dogmatic in Germany, towards politics in general. And my example is the idea of private autonomy, which did not become a foundational legal principle in Germany before the second half of the 20th century. And that is probably in opposition to what 99% of German private lawyers actually think. So I have a little handout for you, so only in order that you can follow my talk. And I begin with the first point, der Kampf ums Recht. The most successful academic book on the German legal book market ever was a Kampf ums Recht, The Struggle for Law. That was Rudolf von Jherin's inaugural lecture in Vienna in 1872, 1 year after the German-French War. The title was based on Darwin's Struggle for Life, and Darwin's battle metaphor was omnipresent in public debates in society, the economy, and foreign policy. Jhering was concerned with the political character of law. He's very explicit about that. He considered the law from an external point of view rather than from the internal perspective of pure doctrinal or dogmatic, as he had done earlier. And from this point of view, the law appeared as a product of struggles between conflicting political interests in society. Now, Savigny had claimed that the law developed through what Savigny called internal, still working forces. In contrast, for Jhering, the law was the result of fights or struggles. According to Jhering, this was a blessing. The struggle that law requires is not a curse, but a blessing. Now, actually, these were quite difficult words for a man who had just lost his wife's domestic war with her maid on the public stage of the municipal court of a province town in Gießen. Deeply offended at that embarrassment, Jhering had left town and country. But the man did not give up. He lifted the dispute from the provinces to the big stage of academia and made the fight a moral duty. Everyone, the lawyer and academic, as well as the citizen, was called upon to actively participate in defending their rights and in shaping the law. What was precisely in such struggles over the law that the fate of societies was decided. Now, the law was the product of struggles and therefore of politics. Of course, this view was not fully new. In the Enlightenment, the whole idea of a non-political, technical private law had been a means, a political means to further society's well-being and other political goals that has resounded such ideas in the 20th century in Germany. Hegel's philosophy of private law was deeply political, even in its foundation or conceptual basis of property as an external sphere of freedom. Also, Savigny, against Heering, was taking a stand here, had seen the political character of law very clearly. However, Savigny had pursued an opposite strategy. Savigny had distinguished the political elements of the legal order to be regulated by legislation, that is, by politicians, from those areas of the law that were the subject of a technical jurisprudence. Hence, for example, the strict separation of property and obligations. According to Savigny, the allocation of property rights formed a subject of state politics. Controversial questions, such as the entailed estates of the nobility, were therefore not a subject of legal knowledge, but of political decision. Only the state could create such property rights, while possession belonged into the law of obligations as an instrument of interpersonal protection of freedom. Even there, of course, were positive political elements. Savigny was not only a scholar, he had been a minister of justice in Prussia. And as such, he had, for instance, become the father of modern strict liability, which he had launched in the Prussian Railway Act. Yet Savigny never spoke about such liability in his academic writing. Neither in his System des heutigen römischen Rechts, so system of contemporary Roman law, nor in his law of obligations, Obligationenrecht. Science could only make authoritative judgments and claim a leading role when it was able to interpret the law as a product of silent forces and control it through doctrinal technique. The strategy of the historical school therefore consisted in keeping politics out of the legal science, though never keep out overt value judgments or a sense of justice or even God. The Pantheistes were quite free to speak about that, but politics had to remain outside. Savigny's doctrine thus breathed, it may be, if I may put it in such terms, the spirit of Biedermeier bourgeoisie, shielded from the political sphere of the state. Now, second point. Heering's book was, of course, a success, not least because at the end of the 19th century, Savigny's vision of apolitical scientific private law was about to fail. Nobody really believed it properly. It had become evident that political decisions had to be made also in core areas of private law. Issues that were discussed at the time were, for instance, the effect of contractual prohibitions against assignment or standards of care in the law of delict. Those are deeply political questions, and they had to be answered politically. Nevertheless, when the codification was drafted at the end of the century, the concept of the historical school seemed to prevail once again. Only the classical matters of private law theory found their way into the codification. What did not appear to be sufficiently politically stable or scientifically clarified remained outside the codification. The Installment Act of 1894, for instance, as well as labor law in general, and regulation of domestic servants in particular. Likewise, the code did not touch on strict liability, which had already been regulated before in separate acts of legislation, again, outside the codification. Gottlieb Planck, the father of the codification, and certainly a political mind who knew what he was talking about, stated authoritatively that social innovations are to be left to special legislation. The dividing line thus no longer run between property law and obligations, but rather between the codification and non-codified law. Political, according to the guiding intuition, was what was currently in struggle. More specifically, all new law, as well as all regulations that preferred the interest of one class or the other. That is the words of Planck. In contrast, the roots of a core private law that were generally accepted in the academia or even considered evident or axiomatic were considered apolitical. Hence, the deep conviction of the non-political character of the codification, which united, interestingly, the fathers of the codifications with its many critics who lamented the missing drop of socialist oil. Now, this intuition was never plausible. The unification of private law had required politically difficult decisions, not least in inheritance and property law. Many provisions of the BGB had been discussed in a highly controversial manner in the commissions and above all in the Reichstag, so in the parliament. And these debates never came to an end in 1900 when the codification was went in force. Thus, the first revision of the new code exempted the commercial animal owners from strict liability. Here, the Reichstag, so the parliament, after intervention by the farmers and the haulage lobby, adopted a proposal which had, funnily, originally been suggested by the second commission preparing the draft of the code. Ironically, this proposal had been rejected by the members of parliament, who now opted for having it. So having strict liability was obviously no more political than rejecting it. But such discussion did nothing to change the new law's apolitical reputation. As a result, hardly anyone was happy with the code after 1900, and the courts were very quick indeed, in politically deciding against the code. Examples were the introduction of strict liability for servants by extending contractual liability, or broad extensions of liability for negligence, or the reintroduction of the clausula rebus sextantibus, or the invention of unfair terms control. Much of this was done quite consciously against the intentions of the codification's draftsmen, in the same sense that links to what Oliver has told us today. Clearly, it was highly political law, but it was introduced in the form of apolitical, scientific, doctrinal argument. Now, I pass over the fierce debates on legal science. I'm now in 3, and its methods in the early years of the 20th century. A keyword would be Kantorowicz, the struggle for legal science. And I pass also over the dark times between 33 and 1945. Throughout all those years, legal scholars relied on what they perceived as legal truth to relativize the codification and to reinterpret it in terms of first of social justice and then of Nazi ideology. In accordance with the program of the Nazis, like Carl Schmitt, they, and I'm now citing Schmitt, altered the entire law without rephrasing a single positive legal provision. Now, you might think that in the 50s and early 60s, it would have been time to rethink what had happened before, but that was not what scholars did. They did not look back, nor did they revise their attitude towards the code and legal science. Nevertheless, there was a growing feeling that traditional legal scholarship was in a crisis, and that courts, rather than scholars, had become the oracles of the law. The obvious thing now was, or seemed to be, to focus on doctrine in a very narrow sense, rely on the provisions of the codifications and to avoid again all politics. And the most significant expression of this changing attitude was the rise of the commentary as the normal format of legal scholarship, and also the corresponding decline of the traditional systematic textbook. The textbooks were always based on the idea that the scholar invents what is really important in law and puts it against the words of the codification, and so to speak, put new light on the codification by having a system in which to place them. And that is what most scholars now stopped. They rather took the system of the codification as it was and began simply to read them quite literally in the commentaries. Now, It seems to correspond with this new focus on legislation when Coing, a really leading scholar in Germany in these years, explained in 1957 in the Staudinger, the leading commentary, the organizing legal principle of private autonomy. And when since 1976, the Parland, as it was then called, that is the book which every lawyer in Germany has on its table. And when the Parland explained, when the Parland stated, and still states, civil law is based on the principle of private autonomy. Full stop. In the Parland, private autonomy was and still is a legal principle that promised to provide orientation for doctrine. With this argument, Heinrich, that was the commentator in the Parland, largely relied on Flume, who had made private autonomy the conceptual and programmatic focus of his Die Lehre vom Rechtsgeschäft, and that was the last systematic textbook on the BGB. Yet neither Coing nor Flume had mentioned any legal basis for private autonomy. For Flume, private autonomy was rather a principle to be realized in the legal system. It was at the disposal of the legislator, who was free to exempt the matrimonial property regime from private autonomy or to limit possibilities of testamentary arrangement and to convert the law of obligations to mandatory law. Nevertheless, private autonomy for him was the obvious starting point for any legal argument, and it was justified independently of the provisions of the BGB of the basic law. It was justified in the respect for the self-determination of the subject. That was Flume. Heinrich, in contrast, based private autonomy on the freedoms of contracts, of association and testation, as well as on the freedom of property. And he referred in each case to specific legal provisions in the Codification or in the Grundgesetz, so the Constitution. The prevailing doctrine thus began to anchor autonomy in the BGB, and they thus made private autonomy a legislative and thus non-political basis of legal doctrine. Yet what seemed evident in the late 1950s had not been anything like that before. In the preliminary editions of the Parland, the term had appeared as little as the matter itself. Until 75, in the places where Heinrich now explained autonomy, if you look there, you would find definitions of basic doctrinal concepts, no reference to any normative principle. Sometimes scholars had, of course, spoken of freedom of contract, yet the limits and restrictions of freedom of contract were much more important than the principle. According to Alexius Lehmann, that is then the leading textbook, freedom of contract was largely abolished by legal regulation, collective agreements, and general terms and conditions. Until 1960, the Parland held similar views. Now we take again a step back to Weimar. Much of that had been written under the impression of the Nazis and the Allies' public control of economy. But even before the war, few had thought differently. The BGB was supposed to be apolitical. It did not pretend to be more liberal than it wanted to be social. And the scope of freedom of contract was politically contested. Freedom of contract or autonomy had only been mentioned very exceptionally and in rather trivial context. For instance, private autonomy was used to explain that citizens could conclude contracts at all, and that a sufficient contractual agreement depended on what the parties wished to arrange. That was what was justified with private autonomy. Of course, jurists assumed that citizens could provide for their private legal relationships according to their preferences. Yet this was a pre-legal assumption, not a legal principle. Even in the Weimar Constitution, freedom of contract was only to apply, I'm now citing the Constitution, in accordance with the law. So it was at the free disposal of the legislator. Wartime economy had suspended it in wide areas of everyday life. Thus, even where it was restored after the war, it had lost its self-evident nature. The other commentary literature thus neither discussed private autonomy, nor freedom of contract, nor any theory of contractual obligations. Planck did not even include freedom of contract among the great principles of modern law to be taken into account in the assessment of commercial competition clauses. Likewise, Krome, another textbook, stated in that the so-called private autonomy was not a source of law. And for Ennemann, private autonomy was merely a generic term for freedom of form and freedom of content, and he warned against combining both principles. Such an extended private autonomy has never been enforced, nor will it be in the BGB. According to Ennemann, it was not even sufficient for a contract that it did not violate legal prohibitions. Rather, every contract required an interest worthy of protection or a legally recognized reason for that. That is the old gemeinrechtliche, jus commune doctrine of causa. Anaxirus, one of the fathers of the BGB, took the same view. Thus, in 1900, neither the BGB nor doctrine had spoken of contractual freedom or private autonomy as legal principles. Yet this did not initially mean that people now wanted to think more liberally. Most scholars addressed freedom of contract not as a basis of private law, but only in the second place. But this did not mean that people wanted to think more liberally in the 60s when they began to speak about autonomy. Most scholars addressed freedom of contract not as a basis of private law, but only in a second place, as a limit to equality postulates. Reiser was the first to think along these lines in 1946, expected post-war society to embrace a new value system characterized by socialism. For him, freedoms under private law were thus limits of the basic principle of equality. Freedom of contract and competition, as he emphasized with reference to standard ordinable literature, never had absolute validity. Their function could only be properly fulfilled if certain economic conditions are met. Where scarcity was to be distributed, the principle of equality was therefore a requirement of objective law. Now, of course, in 1946, nothing of that was based on thorough reflection, and Reiser was unable to state any legal basis for his argument. With the basic law, however, his argument suddenly made much sense. Other scholars argued that private autonomy, together with the freedom of marriage, were the decisive limit to the basic law's principle of equality. With repeated reference to Reiser's texts, they emphasized that private autonomy allowed contracts to be concluded or rejected at will, that is, also to choose contract partners at will. Conversely, however, the principle of equality also had an effect on private legal transactions through the provision against contra bonus mores. There was therefore an interaction between freedom and equality. Dürich, a leading constitutional lawyer in these years, argued in the same way to justify his doctrine of limited indirect third-party effect of constitutional rights. Whereas for some scholars, private autonomy was a basic principle of our entire legal systems, recognized, for instance, in the different federal state, in the different states' constitutions. Dürich justified autonomy with the new constitution as a whole. In private law literature, too, autonomy soon became a constitutional requirement. It was thus given the legal form of a basic legal principle, yet its political core was again dissolving in doctrinal debate. Now, by the mid-70s, despite increasing uncertainty, civil law scholarship had taken a new, quite firm form. The intuitive distinction between political and non-political law remained fundamental. A foothold was found in the commentary as a form of academic publication, in legislation-oriented methodology, and in private autonomy as a normative anchor. While the death of contract was proclaimed nearly everywhere in the world, only a minority in Germany doubted the possibility of an unbroken liberal dogma of private law. Most civil law teachers avoided basic theoretical and political questions. Without explaining this in more detail, they understood private law as a system of corrective justice with autonomous subjects. Private law, it was assumed, was almost exclusively about two-party relationships And the problems resulting from antisocial consequences of freedom of contract were a matter for the legislator, not for themselves. The eminently political and thus system-breaking consumer law was special private law and to be understood as a countermodel to established private law thinking. Zoellner fundamentally doubted whether the welfare state was allowed to use private law to pursue its goals at all. So such private lawyers would even argue that that was all public law. However, the pressure on this model of private law was growing. Scholars increasingly saw private autonomy and at the same time their apolitical self-image and academic autonomy under threat. One factor was that time and again, the Constitutional Court intervened in core private law, and the European legislator increasingly interfered in contract law with regulatory consumer regulation. The profession began to defend the autonomy of the subject. As I had observed as early as 1957, that the dogma of the will had long ceased to defend the interests of the property classes. Now, private autonomy had become a safe, as I writes, a safe redouit for all classes against the interventionism of the welfare state. Private autonomy was not only taken to explain private law and to direct its doctrinal development. Now it was meant to protect private law. Scholars brought private autonomy into a frontal position against everything they perceived as an external irritation of private law thinking. Lehman, I'm sorry for this name dropping. Just all names I'm speaking about were extremely famous scholars in their times in Germany. So Lehman, and that is the only thing I want to transport. You don't have to know them, and you don't have to associate anything with them. So Lehman had coined the formula of the softening of the bones of private law in 1958. And again, you might think that that was an impetus to reflect the doctrinal inheritance of the Weimar and Nazi eras, but that was certainly not the case. It was directed against the legislator. Last page. Lahren spoke of a restriction of contractual freedom by the basic law. At stake, as Diedrichsen later put it, was the sovereignty of civil law. Now, again, this was not new in itself. After 45, as we have seen, private autonomy had indeed functioned to limit the principle of equal treatment. From the outset, it thus had a constitutional significance. Nevertheless, the frontline position against external actors meant a significant shift in emphasis. Only now did freedom of contract become a political argument in constitutional debates. Once again, civil law scholars knew better than the legislator and better than the Constitution and its court. The self-restraint of the Bonn Federal Republic was a thing of the past. At the same time, fundamental patterns of perception and normative assumptions shifted. In the 50s and 60s, people had looked at contractual practice with an undistorted sense of reality. Authors such as diverse actually as Lehmann, Cohen, and Flume had agreed that private autonomy was threatened above all by the use of general terms. After all, the core of private autonomy was the ability to actually make free choices and free decisions. Yet already in the 70s, many began to think differently. Now the situation of private law dogmatics distorted the view of economic conditions. Lieb could expect broad approval on the Civil Teachers Association when in 78 he spoke of the danger for private autonomy to subject the reasonableness of general contract terms to judicial review. A few years later, he complained about an increasing legislative paternalism. So the danger was no longer contractual practice, but its regulation. Contractual freedom was increasingly understood in a purely formal sense. Zoellner, I've spoken about him before, even decoupled private autonomy totally from the idea of self-determination and from its constitutional basis. private autonomy was now endangered above all by statutory provisions on consumer and employee protection. That was the danger to private autonomy. Now let me conclude. What I wanted to show to you is actually quite simple. The private lawyers I spoke about were probably deeply convinced to defend an apolitical conception of the law and legal thinking. Their motive to do so was probably not political convictions, but a habitualized sense that traditional claims of legal science were based on their apolitical expertise. Now, today we know better. Few of us, however, have understood that we therefore also have to reinvent legal science. What academics can do today is no longer produce and to pre-think solutions which courts have to find. Rather, we have to develop options or models for judicial decision-making and legislative regulation. We have to open up perspectives, so to speak. But that would be a different presentation. Thank you.
Thank you so much, Niels. Questions? Ronaldo?
Okay, so impact or reflection of American discussions, in particular on death of contract and economics in Germany. Answer is probably rien, nothing. Very few Germans in these days had gone to the United States. Many of them were not very fluent in English even. There were exceptions, of course. Esa knew very well. Fikenscher knew, but Esa was actually the only one to bring some ideas back to Germany, and certainly not those ideas. The answer is no. And it's really remarkable that in those years, German private law doctrine went on a very, very specific way, which was not connected at all to what happened internationally. I think it's fair to say, to put it in those terms. It was not necessarily wrong. I mean, as far as I see, still many people, in particular from the Iberian and South American world, look to Germany, in particular, and to German private law in particular during those years, although, and also Italians, by the way, although they were quite aware what was going on in the United States, but they, thinking in terms of private autonomy has values. I mean, I have not spoken on that, and I do not want to discredit it at all. But it is political, and its political nature needs to be reflected, and that was never done in Germany. Yes, so Hegel. I would, yes, you're obviously right in everything you're saying, but in the 20s, nobody in Germany, no private lawyer in Germany would look on private law from the outside. It's a great time. It's a high time of the historical school, and they take a purely internal view of the law, and actually. New perspective on private law, perspective from the outside, functional interpretation of private law begins not before Jering, and not before the later works. I mean, Jering had always a functional understanding of doctrine, even in his earlier years, but he made it express in a sense only with this Der Kampf ums Recht in 72, and then with the purpose in law. The difference between private and public law, yes, I would think there's still a difference, although it's not so important. I would say the main differences hinges on the correlativity of private law relations. When you have public law regulation, the state can speak, so to speak, to all citizens individually as members of society. When the state uses private law as a means of regulations, it has to speak to citizens as partners to contractual relationships, or as people who are connected through a delict also. So the state has always to consider the correlative connections between different parties, because that is what makes the essence of private law. It's not that it's only about corrective justice or anything like that. I would never argue anything like that, but it's the correlativity of the relations between private law subjects, and using such relations or regulating upon such relations is in many aspects different from regulating directly vis-a-vis individual citizens.
Thank you. I've seen hands from James and Oliver. James. We don't have any Brazilian colleagues who at least vigorously claim the floor, so
I look forward to reading the paper. One of the things is I look at we were reading and discussing some of the things when discussing one of the things. What would you say at the end about how we need to do matching? So some of the things that you at the place of the earlier points would also be easily connected between who might maintain here. Right. So how much do you think of your proposal as undermining those things? So to ask more specifically, if legal scholars are not right politics and they're treating doctrine as or if they're not thinking of the possibility of discussing something in academic terms as a measure of education, and they're instead switching to stuff with the independent proposals of different ways in which the interpreters might have their own dominant foundation. How much undermine the idea that we look at doing the whole stuff a certain way, and I want to follow it to make it other kind of It's interesting to listen to all these presentations by former colleagues of you. They have to say about autonomy and freedom of contract, written case, so to say, for private law. What I found very surprising is that obviously they never mentioned legal entity, living person. When I think about actor in private law, I don't think of real men, and I rather think of corporations, associations, and legal entities. Those are the bodies that really profit from private law, not you and me. Actually, what can we do with the means of private law, you and me? Fulfill our personal strong situation. The actors who really profit from private law are associations and corporations, legal entities. And what I find surprising is that those entities obviously are not in the mindset of our esteemed colleagues of the 19th and the 20th century. Is that a wrong perspective, or if I am right, how can you explain that? I mean, because I think it's naive to talk about autonomy when we, on the other hand, have actors that are corporation. A corporation does not have an autonomy.
Okay. James, well, let me put it that way. I personally would make such proposals because I'm fully aware of the political nature of private law thinking. That's my way or my order of thinking. And I think that we have to really find our role because also private law in its core is highly political. And I would actually also think that by opening perspectives in itself is apolitical. The designing models in itself is apolitical. It's as apolitical as mathematics also. Applying them and using them, that is the political matter. Quite ironically, science could become science again, and science is and that's less political. But would it undermine? I mean, in a sense, yes, of course. In a sense, yes, of course. Because as teachers in the classroom, we would no longer tell fairy tales to our students. If I put it that way. But I would not think that it would directly lead to politicize the law in the same way as it has been politicized, for instance, in the United States. Because still, we would take doctrinal perspectives. Still, we would try to find impartial, rational, intersubjectively explainable solutions. But we would ask our courts to take responsibility for the decisions they made. That would be my answer. Yes, that's all. Oliver, I think my short answer is every company has owners, and companies are means for owners and for owners who are autonomous in founding them. I think usually as private lawyers, we do not specifically focus on companies, mainly because we know that there are always people behind them. And the real thing of the company's autonomy is the owner's autonomy. behind them. That is obvious. That is obvious with all small associations and commercial companies, but it's actually, in a sense, also true with big share companies, because everybody. I mean, you to take a normal limited company. That's perhaps that's the dominant participant in German markets, and even if there are, if the GmbH has 1,000 employees or so it's a big actor. There's a family behind it, or 2 or 3 families, and they pursue particular goals. They want to become rich, of course, but even most individual citizens use autonomy mostly in order to become rich, or to fill their preferences. Only very, very rarely in matrimonial law is it about deep affections or so. Private autonomy is in private law is mostly about money, and that does not distinguish companies from individuals.
Thank you so much. With that, Ronaldo, I think you have more details about lunch. Ronaldo, one question. Don't you want to restart at 2 and then make half an hour break between, because we have 4 presentations in the afternoon without a break? That might be a bit too much. Maybe we resume at 2 and then make a half an hour break between the